Author of Malice Aforethought, How Lawyers Use Our Secret Rules to Get Rich, Get Sex, Get Even, and Get Away with It. In your book, you quote a Washington, D.C. attorney as saying, "No lawyer is as bad as the client wants him to be." What do you mean?
Well, I think that's Jacob Stein that said that, and I think it's very much a part of the problem, which is that frequently clients come to a lawyer hoping that the lawyer might have an inside with the judge, or hoping the lawyer, or not minding if the lawyer will inflate the personal injury claim to be a little bit bigger than it might have been. So, the old saying is it's hard to cheat an honest person, and I think there's a little bit of that. If a client has larceny in his or her heart, it's not surprising that sometimes lawyers become part of the enterprise. But I think the larger issue here, and what I've tried to direct this book toward, is we as lawyers are great at saying what the rest of the world ought to do. We define the rules, the rights and the wrongs, and say here's how people should behave. We haven't done so well in doing that for ourselves. And what I try to do is to take the lawyer rules, the rules we write for ourselves to govern our own professional conduct, and to say, look, here's what lawyers say lawyers should do. How well are we doing? And the answer is we're not doing very well at all.
When you say we, are you talking about many lawyers being a little bit out of bounds? You're talking about a few bad apples? What's the state?
I say we very specifically for a reason, and I include myself in the we, because I think, sure, there aren't huge numbers of the 850,000 lawyers in America who are stealing money from clients or taking drugs or whatever, committing murder, whatever. There are some, more than there should be, but they're not huge numbers. But there are, I think, significant numbers of lawyers who are aware of professional misconduct by their colleagues and who do nothing about it. We are a self-regulating profession. So if we don't take care of our own professional discipline, nobody will. The reason I got into this book in the beginning, one of the things that got my interest in the subject matter was there was a lawyer in Philadelphia named Barry Dinker, who I knew well, practiced in City Hall over a period of about 20 years. At the end of his practice, it became clear that Barry had been fixing cases for most of the 20 years. He made an arrangement with the federal prosecutors, and he started wearing a wire secretly, getting evidence which ultimately convicted a number of judges. The funny thing was, Lou, when that became known among the gossip of City Hall, hey, Barry's wearing a wire, a lot of lawyers there got very upset and nervous. No one was surprised. No one, including myself, was surprised that Barry Dinker was fixing cases. I mean, everybody had a pretty fair idea about how Barry Dinker practiced, and also had a pretty fair idea about which judges might be the recipients of the payoffs. And as I've gone around the country here, some lawyers have been critical of the book, and when I've asked them, especially lawyers from large cities, listen, if I came to your city and came to your courthouse and talked to lawyers who practice there every day, could they tell me which lawyers are doing bad things and which judges are part of the activity? They all sort of shrug and say, yeah, actually it's the same in other cities as well. So I think the bottom line failure for the mass of lawyers across the mainstream is we're not as aggressive as we should be in enforcing professional discipline.
You mentioned those lawyers in other cities. What kind of reaction have you had from attorneys to your book?
Attorneys have not been enthusiastic about this book by and large, and in some cases that's an understatement. I've had some fairly exercised reactions. Interestingly, though, I have not had any attorneys saying that it's wrong or that it's incorrect. I've had attorneys say they wish I hadn't written it, that it's too glib, it's too superficial, should have had a more lawyer-like tone to it. But what I really tried to do here was not to write a legal treatise. I mean, there's plenty of them around. I intended to write a book about the rules that lawyers are supposed to live by. It could be understood and appreciated by the non-lawyers, so that non-lawyers and clients can look at this book, can see the professional rules, and say to their attorney, hey, here's what you're supposed to be doing, how come you're not doing it? Because I think the beginning of reform in this area is to demystify it, to make it so a client knows exactly what duties the lawyer is supposed to have, and insists that he do those duties.
You just used the phrase, how come we aren't doing it? Why not? How did the profession get into this condition?
Well, I think, first of all, it's numbers. Only about 2 decades ago, there were something like 300,000 lawyers in the country. Today, it's 850,000 lawyers, and the disciplinary mechanisms have not kept up with the explosion in numbers. There are approximately 300 disciplinary lawyers across the country for the entire 850,000 lawyers. So if you liken it to a sport where the disciplinarians are supposed to be the referees and the 850,000 are the guys playing the game, there's simply not enough referees to make any kind of an impact at all. California has the most. They have about 60 lawyers who are full-time in the disciplinary business. They have over 100,000 lawyers in California. So you can see from that there's simply not enough personnel to enforce the rules vigorously, even if the rules were good. And I think one of the things that it also comes through here is, if you look at the rules and look at how they work in practice, the rules aren't so hot either. The rules permit a lot of kind of cutting the corners and kind of playing the angles a little too close.
Who sets the rules?
We do. Lawyers do. And I think that's a big part of the problem. And I think the setting of the rules, we go through here and, for example, take one example, the rule on fees sounds like, if you read it quickly, like it might have a very stringent impact on limiting legal fees. The rule in many states says a fee shall not be clearly excessive. I kind of enjoy that phrase. Excessive is okay, it's the clearly excessive we're trying to stamp out here. But if you then go and look at the modifications or the kind of the corollaries to the rules, it quickly becomes clear that even a fee, as there was in New York, of $20 million for 2 weeks' work charged by one firm, which worked out to about $5,000 per hour for each lawyer, 24 hours a day for the 2 weeks, even that fee is probably reasonable under the rule that governs fees. So if that fee can be justified, and by the way, they lost that case. It was a takeover case and the company got taken over. But you know, if you have a rule about fees and that fee's okay, it strikes me your rule about fees is probably not too meaningful.
What is a bad lawyer? Are there lawyers out there, the people that you write about, are they doing things that are just unethical, or are they illegal? What's a bad lawyer?
Well, what I try to do here, Lou, to make it, to limit the numbers among other things, is I said that a bad lawyer is somebody who breaks the law or breaks a significant rule of the legal ethical rules, or who does something that he ought to be ashamed to tell his mother. I mean, there are some things that are just fundamentally wrong that, and the example I used for that was John Fetters, who used to be head of the SEC down here, who had a divorce with his wife, and later she contended that he beat her over a number of years and wrote a book about the experience called Shattered Dreams. He immediately went into court to try to get a proceeds of the book royalties about his beating her. That struck me as something so fundamentally against what you would think of as a lawyer ought to be doing. I thought he should be in the category. But basically, the people who I do not include as bad lawyers are the people like Melvin Belli, people who have been very flashy over the years and who may have played very close to the line. But I think Melvin Belli has done some very controversial things. He's also broken some new ground in a number of areas. And so I don't think it's necessarily the flashy person who's getting a lot of headlines who is the problem. I think the larger problem is the thousands of lawyers who go about their business, would like to do the right thing, probably do the right thing, but look the other way when it comes to the professional misconduct of their colleagues.
You write about the temptations that attorneys face. First off, tell us what those are, and are they significantly different than temptations faced in any other line of work?
Well, I think the largest temptation in my mind is cash, and attorneys deal in cash more than anyone in any other line of work that I'm aware of. To give you an example, the head of the ABA a year or so ago at the convention had to embarrassedly report to the police that $55,000 in cash had been stolen from his hotel lockbox. That's a lot of cash. I mean, I've never seen $55,000 in cash. And you wonder, what legitimate purpose could you have to have $55,000 in cash? He said he was a stakeholder in a legitimate dispute. But the fact is, many lawyers will require their legal fees be paid in cash, $5,000, $10,000, $15,000. And I think that makes a fundamental temptation. Some people will cheat their partners. They don't put all the cash back into the pot. Some people cheat their spouses or their ex-spouses by not having the cash available for the alimony payment. It just makes it a lot easier to play fast and loose with the rules if you're dealing in cash. I've suggested we limit cash fees to $500, $1,000, pick a number, and had some very strong reaction from lawyers who have said, well, gee, if somebody's going to be immoral, limiting the cash would not make them more moral. Well, the response to that is, nobody's paying off judges with checks. You know, they're using cash. And I think it's the ready availability of cash that contributes to a lot of the misconduct that we see.
Do you think the ranks of lawyers reflect the population? You know, what I'm getting at is, in the general population, there will be a certain number of bad apples. You've got a large number of lawyers. Wouldn't you expect that a few of them might cut some corners?
Sure, and we're also in a business where corner cutting is in some respects what part of the business is about. I think the difference is, though, I mean, people say, well, how about doctors, or how about engineers, how about somebody else? In all the other professions, all the other occupations, if you commit serious misconduct, whatever the rules of your occupation are, in the end, you're going to be facing lawyers. When lawyers commit serious misconduct, we face each other, and we tend to have a much more tolerant view of it than if we had to face a board of doctors, for example. So I think the fact that we're self-governing and we are in effect the final court of last resort for ourselves means, well, it has a couple consequences. One is, I think we should get some non-lawyers in that process. And many states are moving toward this, and I think if more non-lawyers were involved in lawyer discipline, and if lawyer discipline were not secret, I think that would open it up and get a much higher and better standard of activity and behavior by lawyers.
Talk a little bit more about that process. If a lawyer is suspected of something unethical or illegal, what happens? Who brings an initial charge, and then what happens to that from then on?
Well, if a lawyer is suspected of misconduct, typically the client complains to a state disciplinary board. In the vast majority of states, that act is then secret, and the process that follows is secret up until the time, which is typically years later, when an official charge will be brought.
Okay, now why is that secret?
Well, the reason it's secret now is because lawyers typically say if the public knew, it would affect the public confidence in the administration of justice. I think it's just the opposite. I think that if the public knew, the public would appreciate the vast majority of charges are probably groundless, and it would increase the confidence. But in any case, once that starts, you're in a secret process that takes years. It doesn't take months, it takes years. While that's going on, a couple of other things happen or don't happen. First, if a sister state, and this happened in Pennsylvania, hears rumblings that this lawyer has a problem in Pennsylvania, for example, the state of New Jersey wrote to the Pennsylvania Disciplinary Board and said, would you please send us whatever allegations you have on attorney X, because we hear he's also admitted in New Jersey and he might be doing the same things here. Pennsylvania disciplinarians wanted to do that. The attorney went to the Pennsylvania Supreme Court and said, wait, this should be secret and should stay in Pennsylvania until a final adjudication. And amazingly to me, the court agreed with him. So even though this person was under a serious investigation in Pennsylvania, even though the New Jersey rules would have required New Jersey to keep it secret, they couldn't get the information, and the lawyer went right on practicing in New Jersey. Now, once you have a final determination and a lawyer is disbarred or reprimanded or whatever, at that point, you still have 50 other states where they can operate in. And one of the things that really struck me in this was a lawyer in California killed his girlfriend and was sentenced to prison in California. Harold, in good Pennsylvania, as while he was in California, girl. Well, you are keep your driver for the country, money back, the renewal. So it is a crazy process across the fact that you ultimate state put you out of neighborhood.
Talk to us about the process of doing like this. When you idea to sure and say a or did you go back?
I went to the publisher of lawyers, and we talked around about it. I'd like to do this. And initially, at that point, was to see of all cases that have been reported and decisions, lawyer, which is not as many or available as you might, because the process is.
Yeah, how hard was it to get that?
Well, it's not all that hard because most of what I got ultimately became public record stuff. But and then I tried to develop this in a focus where it could be both readable to and useful to the average non-lawyer, so that a non-lawyer can look at this and say, here's how I can get some protection with my lawyer, or here at least is how I can get my lawyer to obey the rules of the legal profession.
Lawyers don't obviously start off thinking that they're going to do something unethical or illegal, and in your book you talk about the role of law schools. What role do they play?
Well, to start, law schools do not teach lawyers to obey the law. Generally, that is not deemed as part of the mission of law schools. I think there's some very complex intellectual argument about imposing your value system on other people's values, but they don't teach lawyers to obey the law. Pre-Watergate, they didn't teach legal ethics at all. Legal ethics was just a non-existent course in American law schools. Post-Watergate, the ABA has required that law schools include ethics courses, at least one, and I think there are various requirements in various states. So that has been a change here in the last decade or so. But the fundamental point I think that comes through is law schools really don't teach much at all of what lawyers actually do in practice. And again, to go back to my case-fixing friend Barry Dinker there, one of the things that struck me about his activities in Philadelphia was he was secretly recorded saying to a judge, we can get the rhythm going for a nickel, okay? Get the rhythm going for a nickel. Now, do you know what that means? I didn't know what it meant. I'm a lawyer. It meant you can fix the case for $500. And I thought to myself, where did he learn that? He didn't learn that in law school. So it must be that the lessons learned in law school aren't necessarily the lessons that you need to operate either in the court system or out there on the streets. And there is a whole different set of lessons being taught in those environments.
Having to go to law school to practice law, is that a fairly recent development? I mean, 100 years ago you didn't have to, but what changed in that time?
The American Bar Association was very active in requiring that all lawyers attend a certified law school. At this point, I believe there are 7 states which still permit some variation of the old apprenticeship program. Typically, it is so rigid and so onerous in terms of the time required that I think there's only like 1 or 2 states where it actually produces lawyers. But the break point was kind of in the 50s. Up until the 1950s, more than half the lawyers practicing in this country had not attended law school. So it's a relatively recent phenomenon that lawyers actually universally attend law school.
You also mentioned in the book about recent graduates of law schools and the salaries they get going into law firms. How does that affect how young lawyers approach the craft of practicing law?
Well, I think it's another kind of fallout from the 80s, perhaps, but starting salaries in big firms in both Washington, D.C. and Wall Street and major cities across the country have gone from anywhere between $65,000 to $100,000 a year for students at first year of law school. The economic effect of this has been, in order to pay for their time or for the firm to make money on that person, they start out charging anywhere from $80, $90, $100, $115 an hour, and there's no possible way that a student fresh out of law school can have legal information that is worth $150 an hour to a client. It just, it's just not there. So it is kind of a skewed economic system, and basically in any given city the big firms want to compete with each other, so typically they all pay within a very tight range of what the other ones are paying. But again, it has nothing to do with the value of the service provided. It has everything to do with the fact that once Wall Street sets it, everybody else sort of matches it, and you can adjust your billing rates to get it. So it really has, I think, separated the concept of legal value from legal cost, and that is unfortunate for everybody.
In the chapter on law schools, this, as I was reading this, struck me, begins with, when giving legal advice to clients, a professor told our class at Harvard Law School, some lawyers make a memo for their files stating the opposite of the advice given. The opposite? Well,
yes,
why?
Because if the advice is right, you'll never need the memo. And the memo is the idea would be is to cover you when you've given terribly wrong advice, and obviously that's tongue in cheek. But I think it is a little bit reflective of what you can have, and when you appear in law school as an idealistic young student, and if that's kind of the opening exposure to the profession, I think it sort of suggests that there are some aspects that are a little different than the idealism you might have. Another phrase I heard the other day was that somebody said that their lawyer is a very aggressive lawyer, and they spoke very highly of him. And he said, my lawyer always says, remember, you're never going to be guilty until you're broke. So you hear the lawyer jokes and you hear all that, and this certainly is not intended to be a book bashing lawyers. It's intended to be a book that shows how we can make it better, and how the rules of the profession, if tightened up and improved and enforced, could make this profession deliver the service that it ought to give. But the other side of it is, there's got to be some reason why it is we have all the jokes, and why we have polls saying 80% of the people think that lawyers deserve a bad rap. And so I really do think that it is useful to have the public be exposed to the lawyer rules and to the tricks in the rules, and to see if this meets the kind of standard the public expects us to live up to. And hopefully we can improve the situation.
Well, what are some of the changes that should be made?
Well, to start with, I think we should put the rules into plain English so that you can understand them. It seems to me that a lawyer shouldn't lie, cheat, or steal, or kill, or deal drugs. And if you do those things, you should not be a lawyer. It amazed me to find out that a lawyer could hire a hitman to kill his client, and after a 2-year suspension, be back to being a lawyer. I wouldn't think that if you did that, you could be a lawyer anymore. It amazed me to find out that a lawyer could force a client to strip naked and take her photographs and then attempt to sexually molest her, and after a 3-year suspension, back to being a lawyer. So it seems to me we should eliminate all the little close questions, the technicalities that say, oh, there was no moral turpitude, or he didn't really intend it to be that bad. I mean, if people do those kinds of acts, they can do lots of jobs in our society. I don't say they should be locked up forever, but they shouldn't be lawyers. So that would be a starting point. I think then we should beef up and open up the attorney disciplinary systems. We should include non-lawyers as a major part of the attorney disciplinary systems, and we should make that open to public scrutiny. I also think, as I said before, I think cash at the levels it flows through the legal profession is just asking for trouble. I don't think there's any other profession or business that has the amounts of cash that the legal profession does these days. And when they tried to limit it in drug cases, they said that you have to tell the IRS for cash fees over $10,000. Lawyers screamed bloody murder. They said it breaches the attorney-client privilege. We're not going to say who our clients are, who gave us the cash. And I understand about the attorney-client privilege, but I also understand that some of the screaming about keeping the cash secret had to do with reasons other than the attorney-client privilege.
Laudable goals, they're realistic? I mean, lawyers are going to have to change the rules that govern the lawyers.
Yeah, but I think lawyers can do that, and we have shown great flexibility in the past when stimulated by outside events. The ban on lawyer advertising was stricken. The required minimum fees was stricken when the Supreme Court, in both cases, suggested that there might be antitrust considerations involved. So I think that the courts will stimulate the profession in some areas, but I think in other areas, again, back to the rules, if clients come into their lawyer's office armed with the rules and say, let's make our deal in writing as far as the fees, so we don't have a fight about that. Let's understand what this case is, what it's going to involve, and what my chances of success are, and tell me up front, how you see the problems. I don't think clients expect guarantees, but they'd like to have a realistic idea. And I think if that's backed up with some client understanding of what the lawyers are supposed to adhere to and what standards they should meet, I think you'll find lawyers paying a lot more attention to those standards themselves.
For our viewers who may be asking the questions, who may be wanting to deal with a lawyer, let's follow that up. Where can they find out about what these rules are? And then what questions should they ask when they go see a lawyer?
Well, the rules are in every county library, in every lawyer's office, and in the back of Malice Aforethought. I've reprinted a set of the basic lawyer rules. There are several variations, but the variations are fairly minor from state to state, and basically all states work off the American Bar Association formulation of the rules. So I think that's the rules are readily available. But typically, lawyers don't advertise the fact that they're available. One of the very key things in the rules that clients need to know about, but typically don't know, is there something called a client security fund. It says if you lose money that you've left with your attorney in a trust account or an escrow account, most states now have a fund funded by lawyers where you can get some of that back. Recently, an attorney in New York skipped town with $15.5 million of client funds, and unfortunately there are limits on the client security funds as to how much you can get back, but clients should be aware that these funds exist just like FDIC insurance. I mean, that's something that the client should be aware of when the relationship starts. As far as the questions you should ask your attorney, I think they're basic fundamental questions. How much does it cost? How long will it take? And what are the chances of my prevailing in this matter? I think one of the problems has been that we like to mystify what we do. We like to make it sound more complex and probably more challenging than it really is in many cases. And I've tried to demystify what lawyers do in this book. And I would encourage clients to ask questions they may think are foolish or elementary questions, but they're probably not. They're probably good questions, and I think they should ask their attorney and expect answers.
You've mentioned several times the American Bar Association. What do you think of the ABA?
Well, I think it was formed in the late 1800s for the same purpose as most unions, which is to raise the economic and social status of its members. And I think it has done an admirable job of doing that, and I think it has done an abysmal job of really aggressively providing leadership in the disciplinary area. And several years ago, there was a proposal that the ABA get actively involved in a review of existing disciplinary standards and how effective they are. That hadn't been done for about 20 years. And the ABA has about 300,000 members and over 100 committees. And at that point, somebody wrote an internal memo that said, we have all these committees, 7 or 8 of them, which dealt specifically with discipline. But they're all busy, and they wouldn't be able to get to this for another couple of years. And then maybe even if they got to it, that we should get some outside body. So as of now, there's been no serious ABA effort on discipline yet. And one of the responses of the ABA and other lawyer groups to criticisms about lawyer behavior is typically that it's not a discipline problem, it's a public relations problem. It's a PR problem or a marketing problem. If we could just get the public to understand our image as it really is, maybe hire a new marketing consultant, and we'll finally get across, how well we're really doing. I don't think that's the problem at all. I think the public perceives quite correctly how well we're doing in the disciplinary ethical area, and I think that's the major reason for these polls that show people have a terrible opinion of lawyers.
Do bad lawyers go on to become bad judges?
Well, in some cases, yes, hopefully not many. The problem is that under our system, starting with the Supreme Court, there's no real requirement as to how you get to be a judge. There's not a judge school, for example. There's, we see the police academy and the schools for various other kinds of activity, but there's no judge school. So you either run for election or you get selected by a panel of bar association or other leaders. So someone who has been a bad lawyer can well go on to be a bad judge. And the problem at that point, Lou, is judges, unlike lawyers, should not be directly accountable. The judges are a separate branch of government. It's part of our balance of powers. And we would not want to have a system where you had somebody overseeing judges and imposing discipline on them to the same extent that we would expect that with lawyers. So the only people who can really effectively discipline judges or impose any kind of standards are lawyers, the lawyers who practice in their courtrooms every day. And the I think, troubling statistics, you never really know how well the judges are doing because each courtroom is independent, nobody keeps track, and if anybody is taking money or payoffs, they're not advertising that. But the two times there have been massive undercover FBI investigations of judges, once in Philadelphia and once in Chicago. In Philadelphia, a union made cash payoffs to judges. The union messenger took cash to 16 judges. 15 accepted it. 1 turned it down. Nobody called the cops. In Chicago, the Operation Greylord investigation undercover convicted 45 lawyers and 15 judges over a several-year period of payoffs. Now, it strikes me that just human nature, you can't have 45 attorneys and 15 judges conducting illegal activity in a given courthouse without many, many more people being very much aware of that. So those two statistics, I think, are very troubling. But as I say, we need to be very cautious about imposing outside discipline on our judges because it's a separate independent branch of government.
We talked earlier about what advice you have for our viewers who might be interested in hiring an attorney. Let me close by asking you to follow up a little bit on your last answer. You talked about those sting operations where obviously other people knew something was going on. At one point in your book, you say that everyone in the legal profession has a part in lawyer misconduct. Let me close by asking what advice you would have for our attorneys who may be watching or others involved in the legal profession who may be aware of something that's not quite right in the system. What advice do you have for them?
Well, I guess the immediate advice would be to check Rule 8.3, which is the professional requirement to report to the authorities professional misconduct, which a number of legal commentators say is the single most ignored of all the rules of professional conduct. No, we simply don't want to do it. The other thing is I think we need to probably refine procedures for reporting because as lawyers we say, well, look, I have a general idea, but I don't really know. I don't have first-hand knowledge that would stand up in a courtroom, and I hate to, be sending hearsay information in about a fellow attorney. I think we need to have processes where lawyers can make the information available to the disciplinary authorities, even if it doesn't meet the standard of information you would expect if you're going to have a grand jury indictment. And I think if we're going to have the responsibility of policing our own profession, we have to figure out how to do that.
Our guest, David Marston. The book is Malice Aforethought, How Lawyers Use Our Secret Rules to Get Rich, Get Sex, Get Even, and Get Away with It. Thanks very much for being with us.
Thanks, Lou.